Okay, welcome back. This morning we're going to spend some time reviewing our responsibilities as fiduciaries of the system. We have a constitutional obligation to act in the best interests of our members, and this educational session helps us stay compliant with our governance requirements. So here to introduce our facilitator is our General Counsel, Matt Jacobs.
Thank you, Henry, and happy to be able to say something after sitting here for 2 days. Welcome to the annual fiduciary training. As you may know, the board governance policy and the board education policy both require board members to have an annual refresher or training in their fiduciary responsibilities. And what better way to do that than through to learn or those fiduciary responsibilities or to refresh your knowledge of them than through our outside counsel for fiduciary issues, who is Ashley Dunning. I'm going to just go through a little bit about Ashley for those who don't know her, for our newer board members. She is well known in retirement system circles. She's been a longtime fiduciary advisor to pension plan systems in California and beyond. I think she's been doing it for about 20 plus years. She is the newly elected president of the board of the August Association, NAPA, which is short for the National Association of Public Pension Attorneys.
Vice President right now, President-elect, but thank you for the promotion.
President-elect, okay, all right.
I appreciate it.
When does it turn over?
This summer.
Okay. She graduated cum laude from Yale and cum laude as well from the UC Hastings School of Law. With respect to CalPERS, in September of 2016, she was engaged as our interim fiduciary counsel, and in March of 2017, the board selected her as our fiduciary counsel. So with that, I will turn it over to Ashley.
Thank you, Matt. I like to stand when I'm speaking. I realize if I start moving, you can't hear me, so I'll just be right here if that's all right. I have spoken with many of you to give you sort of an overview of fiduciary duties when you onboarded to the retirement board. And so I've tried to not give you the same recitation here as you've already had, but rather go deeper into certain concepts. Well, first start a little bit higher and then go deeper into certain concepts in order to provide you more context for what's going on in this area in current day. I say that, but yet start with a slide with a very famous quote from 1928 from a former Chief Justice of the U.S. Supreme Court, who describes fiduciary duty as something stricter than the morals of the marketplace. It's not honesty alone, but the punctilio of an honor the most sensitive. It is then the standard of behavior. Not necessarily the syntax we see these days, and more eloquent than much of what we see these days, and really impressing upon us how important the role of a fiduciary is. It's important also to understand that there are a number of people in our society who have fiduciary relationships. They exist between agents and principals, wards and guardians, customers and banks, clients and their attorneys. I am a fiduciary to you. Patients and doctors, partners and partners. The partners at my law firm are fiduciaries to me as I am to them. Shareholders and directors, and trustees and beneficiaries of a trust. And that is your role today on this board. It's as a trustee with a fiduciary duty that flows to the members and beneficiaries of CalPERS. In fiduciary relationships, you are asked to engage in a standard of care that is higher than the ordinary degree of care. And it's the one that applies from someone who's considered the dominant or trusted party to those to whom they owe that fiduciary duty. It's that relationship of dominance, of authority, that exists in all of those scenarios that I described, with perhaps the exception of partners. You're equal partners, but you still have fiduciary duties to one another, that defines a fiduciary relationship. The Ninth Circuit, which is, as you know, the federal court circuit that applies to California, federal courts in California and in the West Coast, calls these fiduciary duties the highest that are known to law. What are fiduciary duties? There are two prongs of the fiduciary duty analysis that we need to focus on, and I'll take one at a time. I'll start with the fiduciary duty of care and then move to the fiduciary duty of loyalty. The California Constitution includes within its specific provisions on public retirement boards certain precepts of fiduciary duty, and they relate to the business of retirement systems. The first one I'll focus on, though, is pertinent to all fiduciaries of trusts, and that is that you are expected to engage in the business of the trust as a prudent expert. And the language of the California constitutional provision on this point is quoted here. I won't read it to you. But the key is you are a prudent, so careful, expert, not simply a layperson. You're considered an expert. That may seem daunting to those who come onto the board with expertise that is in other areas. You certainly are not expected to be actuaries or lawyers or investment professionals or doctors. But we will talk about how that plays out in the context of a board where the law places on you this fiduciary responsibility. The guidance on fiduciary duties in cases, which is where we lawyers tend to look for further elaboration on principles that we find in statutes, often comes out of cases involving what I'll refer to, and you probably are familiar with, is as ERISA fiduciaries. So fiduciaries who govern private pension plans that are governed by ERISA. You are not subject to ERISA, but ERISA uses a lot of the same standards that apply to you, and that's because they derive from what's called the common law of trust. The common law of trust and common law do apply to public pension boards. And there's a really important case that came out just 2 years ago called O'Neill, and I've cited it here, that reaffirms the concept that you are subject to common law principles stated under the Restatement of Trusts when analyzing whether there's been compliance with your fiduciary duties or not. The O'Neill case was remanded to trial court, and the tentative ruling came out this morning. So I was just sitting in the parking lot reading that 68-page opinion as quickly as I possibly could, and I will share it with you during this presentation to the extent that I can. But it's sort of hot off the press, and I think extremely well-reasoned. The prudent expert, but staying with the prudent expert rule for a moment, there are certain important aspects to prudent expert rule that I elaborate on this slide. One is, if you have a special expertise on this board, say you do come to the board with a substantial, sophisticated financial knowledge or investment knowledge, or knowledge as a lawyer or as perhaps an actuary, you do not become the lawyer or the actuary and the investment professional for the board, but you do have a duty to share that knowledge with your co-fiduciaries on the board. Another principle is that the fact that you're simply trying to do a good job and that you're, in the words of Justice Cardozo, you're honest about it is also not enough. The famous quote from the Donovan versus Cunningham is, a pure heart and an empty head is not sufficient to comply with your fiduciary responsibilities. There's a case that specifically also talks about this idea of whether you can just be a prudent layperson and comply with your standard of care. And this case says, no, you have to be a prudent fiduciary with experience dealing with a similar expertise or enterprise. So you are held to that prudent expert standard even though you are lay people. And what courts do to assess whether you're complying with your fiduciary responsibilities in this regard is to assess the thoroughness of your analysis, the bases for your decisions, and whether those were reasonable. Were you reasonable, for example, and we'll get to this, in relying on a particular expert analysis? Why was that reasonable or why was that not reasonable? Rather than simply deferring to the fact that you have quite a bit of discretion in your decision making. A case that deals with this that's pretty recent, but it deals with it with a couple of caveats. This is an ERISA case, and it is a case that involved a place where the parties recognized that there was a conflict of interest between the fiduciaries and or with respect to the fiduciaries in the matter at hand, which was the valuation of an ESOP, an employee stock ownership plan. The lower the valuation, the better it was for the fiduciaries. And in this case, it was the plan sponsor and the plan administrator. And the plaintiffs there challenged the fiduciaries for having violated their fiduciary obligations with respect to how the ESOP was appraised. And the court concluded that there was a breach of fiduciary duty, even though in that case the administrator had gotten an independent appraisal of the ESOP from one of the Big Eight. And the rationale was that the appraisal stunk. It was not a good appraisal. And anybody, in the eyes of the judge who reviewed it later, said anybody would know that that was not a strong appraisal. So particularly in the context of a self-interested, conflicted transaction, they should have gotten another appraisal. I mentioned that the California Constitution speaks specifically to some of the duties that you have as pension fund fiduciaries. And one of those is on this slide, and it relates to the duty to assure the competency of the assets of the retirement system to pay the promised benefits. And how do you do that? Well, what is really key to your ability to collect sufficient contributions now so as to pay the promised benefits when they're due is how you manage the actuarial funding of the retirement system. You have the very important and very important quality of the pension plan is that it's actuarially funded, as opposed to having a set contribution rate, which means that you can determine in consultation with your expert actuary what needs to be contributed. You can adopt methodologies and assumptions upon the advice of your actuary, but it needs to be you as the board who has the sole and exclusive power over those services and exerts them in a way that shows that you are being prudent. And we'll talk about loyalty as well, because that's equally important. In O'Neill, which is the case I mentioned a moment ago as having been decided, at least tentatively, by the trial court on the remand point today, the petitioners had challenged the board for various actuarial decisions that they made. One of the allegations was that they'd used an amortization period that was too long. Another was that they'd transferred assets from non-valuation reserves to valuation reserves, and they shouldn't have. That was the allegation. And the claim was that it was a breach of fiduciary duty for them to have done that. The court, in this case, went through a pretty extensive analysis of applicable fiduciary law and talked about the history of how this has developed in California, in particular with Prop 162, which many of you will know was the response to a raid on the Treasurer, raid on CalPERS actually, by the state. an attempt to use funds in a CalPERS non-valuation account as a basis for substituting for employer contributions. And that was roundly criticized and ultimately made illegal by this reiteration of the authority that you as a fiduciary have over the actual services provided to the retirement system. What I find really important about O'Neill, and it did come out in favor of the retirement board in this tentative ruling today, but what's important about it is that it says that even if you're following the plain language of the plan as it applies to you, your plan says you can have a amortization period of a certain amount. The plan doesn't prohibit you from transferring money from one account to another. The plan may have other specific provisions. When making decisions that are discretionary under those plan provisions, you need to continue to be prudent and take those actions in the best interest of your members and beneficiaries. So there's always this fiduciary overlay that applies to all of your decisions. The fiduciary duty of care includes a duty to monitor. And what that means is that you have a continuing duty to mind the affairs of the organization, not as a doer. You're still the policy-driven board, but you have an oversight responsibility. So the fact that a decision may have been prudent on one day does not mean that 5 or 10 years later, the continuation of that policy is prudent. And this issue also was recently addressed in a case that's gone from the Central District of California up to the Ninth Circuit, then to the United States Supreme Court, back to the Ninth Circuit, and back to the District Court in the Central District of California. It's called Tibble. And it was just finally decided by the Central District of California last year in May. It's gone up on one more issue to the Ninth Circuit. But the question was whether, in this ERISA circumstance, the fiduciaries had breached their fiduciary duty by offering retail class mutual funds rather than mutual funds at a price that was available to institutional investors. And basically, it's very important to understand here that the court concluded ultimately that that there was really, that both were available, and they were the same with respect to the mutual funds themselves, but you could get a better price as an institutional investor. And in this particular trust, Edison International had not offered that lower priced, or had not purchased that lower priced mutual fund. The response that the defendant gave in that case was, well, there's a rule, there's a statute of limitations here. We purchased these stocks more than 6 years ago. Under the applicable provision of ERISA, it's a 6-year statute of limitations, and so they're SOL. They've lost their ability to challenge these purchases. And under ERISA, there are also very specific rules, much more specific than apply to most public pension plans, relating to some aspects of how they conduct their business, like the prohibited transaction rule, for example. That's something that applies to them that we only look to for guidance in a public sector context. But there was also this notion that you don't have to review your investment portfolio unless there was a change of circumstances, a significant change of circumstances. And the court basically rejected that concept as it applied here and said the trustee has a continuing duty to monitor trust investments and remove imprudent ones. So again, even though an investment decision had been made to purchase these mutual funds more than 6 years before the lawsuit was filed, there was always a decision that had to be considered, which was, do we need to get rid of those and substitute them for something else? The Supreme Court, the U.S. Supreme Court, did not decide the ultimate issue. They sent it back to the Ninth Circuit, which then issued a very extensive opinion analyzing fiduciary duties. Again, I won't read them to you here, but I gave you a lot of substance on these slides so that you'll have something here that is meaningful if you want to look back and see the language from the court. But as I explain here, it's about the price of these mutual funds and the fact that they didn't have to pay so much for something that was exactly the same. It's going to be rare that you find something that's exactly the same, but in this case, you did have something that was exactly the same. So the Ninth Circuit, of course, vacated the district court's judgment that was in favor of the plan sponsor and sent it back to the district court. And the court reiterated some of these principles that, again, come from common law of trust. They're citing treaties on trusts, which I've cited here. One aspect of this particular case that was important had to do with the fact that the beneficiaries of this trust were impacted directly by how much the administrative expenses were of the retirement system. So that being a cost-conscious trustee actually had an impact on the bottom line for the members, and they talked about that. So the Ninth Circuit then sent it back to the trial court, and the trial court issued its findings of fact, extremely extensive, and found that the defendants had breached their fiduciary duties of loyalty and care beginning 6 years prior to the action was filed by not disposing of the retail share of classes immediately after the institutional share classes were made available. There are some caveats around what the court said on that point, which is why I include the language on the next slide. Because the court recognizes that usually you're not expected to look at this, or the trustees were not expected to look at the portfolio and take daily actions based on some opportunity that might arise. But that in this circumstance, this was a very rare circumstance, and it says in the middle of that long quote, the facts of this particular case present an extreme situation. The defendants never disputed that a reasonable fiduciary would be knowledgeable of the existence of these institutional shares for the mutual funds at issue. So there was no credible argument that they could say, actually, the ones we purchased were better, or actually there was a good reason for us to have held on to them for this period of time. Usually, decisions are more nuanced than that, but they were not here. So judgment was entered in favor of the plaintiffs for $13 million, and so the issue that's gone up to the Ninth Circuit again now has to do with the expert witness fees of nearly $1 million, and whether those are recoverable as well. So what are our takeaways from Tibble? Certainly retirement systems, and this is stated broadly, CalPERS certainly has a lot of systems in place where you monitor your investments, and your large and experienced investment staff do this on your behalf and then report back to you. But you need to have a process that's adopted and implemented to ensure that there's reasonable oversight on a periodic basis. Beyond what you do at the beginning or what the board did before you were on the board. And that analysis should assess whether those investments are complying with the rules that you've set for your managers, say, or for your staff in terms of leverage limits, diversification mandates, what is their role in your portfolio. All of those things should be assessed and reported back to you, and there need to be adjustments made if something is out of compliance. A point we make at the bottom here, I think, is also critical to keep in mind that exclusive reliance on self-reporting by investment managers themselves about how they're doing is likely insufficient, right? You have to have some independent oversight and expertise, which you do through your CIO if you're talking about an outside manager. And if you're talking about in-house staff, then you need to have other ways to assess through your investment consultant and otherwise, as you do. I'm happy to take questions as we go through this. I feel like I've gone through a lot of material. Would anyone like to ask a question now, or shall I plow through? Maybe at the pleasure of the president, if you'd prefer one approach over the other.
Yeah, if any member has, if they have a question, please let us know. But I don't see any at this time.
Okay. All right, so I'll stay with investments, but move to diversification of investments. So this is another provision that's in the California Constitution specifically, and it is a mandate. You as a board are now required to diversify the assets of the system in order to minimize loss and maximize return. Now, this is quite different from the way that the trusts were originally, or pension funds originally were set up. Originally, you were very limited in the types of investments that a CalPERS or another California public pension plan could invest in. And then there was a list. You could invest in this type of, only these types of investments. But it's evolved over time with the evolution of modern portfolio theory. And now it's a prudent standard, and diversification is key, or is viewed to be key. Now, there is a slight difference on this point in the California constitutional language than even in ERISA, because which is that under California law, you have an even stronger diversification mandate, because it says you must do so unless it's clearly not prudent to do so. So if it's not prudent to be in a particular asset class, if it's not prudent to be in a particular type of asset for the reasons that you've reasonably determined, then you can divest. But you have to have made those findings. When putting this language into the Constitution, there certainly must have been a lot of discussion about the fact that at least CalPERS and CalSTRS are subject to quite a few divestment mandates from the legislature. And what the Constitution says is that the legislature may continue to impose those mandates so long as, and here's the Fiduciary Savings Clause, provided that the prohibition satisfies the standards of fiduciary care and loyalty that are required of you. Which is why, whenever you're facing a divestment mandate, it is critical that you go through the fiduciary analysis to determine whether it's prudent and whether it's in the overall best interest of your members and beneficiaries to actually divest. Another aspect of fiduciary duty relates to consulting with experts. And the restatement of trust speaks to this and says, to the extent that it's necessary or appropriate for you as a board to make informed, here it says investments, but it's really informed judgments, the duty of care requires that you consider the advice of secure the advice of others, or if you need the advice of others in order to make an informed judgment, then you should do so. And you should do so on a reasonable basis. And it applies to all of the areas that you have authority in, so administrative and investments. The implicit corollary to this duty to consult with experts is if the fiduciary fails to show that you're following the recommendations of your experts, you need to have a reasonable and informed basis for doing so that is grounded in the expertise that's at issue. So for example, if you're talking about an actuarial matter and your chief actuary has made recommendations to you and you are dissatisfied with those recommendations for reasons that you articulate, a decision to do something else either needs to be supported by your chief actuary, or you need to have other actuarial experts in front of you to present those recommendations. It's not appropriate to simply ignore expert advice. But again, you're not a rubber stamp. You're ultimately the decision maker. So you have to make that determination. There are also, yes.
Ready.
Thank you. I wanted to see if there were distinctions to be made here, but on these provisions that are providing for statutorily provided divestment that are in the Constitution, would those carry over into board-initiated divestment proposals as well?
It would have to be fiduciary, it would have to be prudent and in the overall best interest of members and beneficiaries. So, and there's an even higher hurdle to meet, perhaps, if it's not legislatively mandated in light of the diversification mandate. So I wouldn't say that you couldn't, but you have two hurdles then to meet. One is your decision to move out of something it's clearly not prudent to be in that. I mean, maybe it's not another hurdle. You have the specific authority under the Constitution to engage in this analysis if the legislatures impose the divestment mandate. If you're creating it yourself, you don't have that, but you have your overall fiduciary analysis and responsibility that applies.
So would it be fair to say that on any matter that comes before us, whether it's a divestment question that's initiated by the board, or maybe a reinvestment question of what we previously divested from, begins with that fiduciary analysis?
Absolutely.
Okay, and then, and I guess, what would that entail? And the reason I'm asking is because I've been
Right. Well, what that entails is true evidence, not simply speculation and theories. There needs to be material in front of you that you can rely on to make a reasonable conclusion, reach a reasonable conclusion that it's in the overall best interest of your members' retirement security and other matters that relate to their engagement with CalPERS. So this case, O'Neill talks about employment security to some degree under certain circumstances, and prudence. And so in some places, you'll have competing experts. You'll have experts who say, you're a long-term investor, and so if I look at the long-term trajectory of this particular topic, here's what I see, and it looks awful. And here's the evidence to show that. And then you have somebody else who comes in and says, well, no, if you do this now, you're going to lose X amount of money, and they're only looking at the short term. Well, maybe the analysis then is long-term versus short-term trajectory. I've certainly seen that. But that's the type of analysis. It has to be real. It has to be grounded. It has to be grounded in what you're looking for, what your responsibility is, to ensure that you have the assets on hand to pay the promised benefits of the members and beneficiaries when they're due. That's your fundamental highest responsibility as trustees on this board.
Okay, Mr. Miller?
Actually, I had a couple questions, but I think you just answered some of it, because I was thinking about, that long-term versus short-term, that some decisions which are made in the interest of either our diversification strategy or being a long-term investor, but that may result in short-term losses. So I think you covered that. So the next kind of thing is, in terms of the execution of our decisions, how do we, if we did decide to, in order to diversify, to reduce our concentration in something by divesting, to do that, is there much emphasis, has there been much emphasis from the courts or challenges to how we execute that, whether we execute that in an orderly way or whether we make a big announcement and dump everything the next day and get clobbered in the market or whatever.
Process is really important. And this decision I was just running through very quickly this morning went through point by point what the actuarial expert said, what the fiduciary expert said, what the rational basis was, or what the reasonable basis was. In the context there, the issue was the Great Recession, and the market had tanked, and the question was, what's the best way to ensure the stability, the actuarial soundness of this fund for purposes of its long-term ability to pay these benefits? Yes, there was going to be an immediate benefit to the employer by taking these steps to decrease the impact of the Great Recession. But in the long term, this was a much more prudent step than ignoring it and just saying, well, you got to pay twice as much as you paid last year. But that was the analysis. It was in the context of that event that it was considered. So yes, to answer your question about doing something suddenly versus over time, it depends on the question, right? So if you're talking about a circumstance like was addressed in Tibble, they said, well, once they found out that there was an institutional share that was available for less cost for exactly the same mutual fund, they needed to immediately take action. There's an action where you act immediately. And then there are other circumstances which are far less clear. If you're changing something fundamental about your portfolio, that is something that warrants more deliberation, consultation, time, that sort of thing. You're welcome.
Okay, Mr. Ruffino.
Good question.
Just a quick question with respect to the divestment mandate by the legislature. Is there any case law where the legislature mandate and a pension board did not agree, either in this board or other boards? Is there any case law at all?
I don't know of that particular case where the challenge was to a failure to follow a statutory mandate. I don't know of that case, although it certainly could arise. There have been cases under ERISA where divestment was successfully challenged as a breach of fiduciary duty.
Mr. Perez.
Thank you. When reading the laws in context, are they applied to us, excuse me, as a board or individually? If there's half of us that say, let's get out of these widgets, and it turns out to be bad, and
Right.
we violated.
You act as a board. You act through the majority of your voting members. And typically, actions are brought most properly against a board rather than against individual members. And typically, individual members can be removed from lawsuits based on California principles relating to both immunity in certain circumstances and discretionary authority in others. That said, it's up to the plaintiff whom they name, right? So whether a particular trustee is named or not, and whether the retirement system is successful or is able to have that named trustee removed as a defendant in the case is up to the particulars of that particular circumstance. So I'm sorry I can't give you a definitive answer on that. I think ultimately it's the organization that's usually on the line, but not necessarily. If individual board members are engaging in conflicted transactions, for example, they're lining their own pockets, most definitely, not only is there a fiduciary breach, but there's probably a crime.
So basically, do I need to put my house and everything in a trust?
So this is a general fiduciary training. you know, there are protections under, some protections under California law for public officials engaging within the course and scope of their responsibilities in their official roles. There's a lot of protection. But there is a reason why we're having fiduciary education. It's to train you to act as prudent fiduciaries who are acting in the best interests of your members and beneficiaries. So I'm not trying to scare you into thinking that the sky's falling in, but these are serious responsibilities, and you all need to take them very seriously. And you are all co-fiduciaries to one another as well. So in the context of discussing matters together, to say simply, oh, well, I voted this way, so I'm fine. I don't know. I mean, I think ultimately it's all of your reputation that's on the line, and all of you who are on the line if CalPERS gets sued for a breach of fiduciary duty. Doesn't mean that the lawsuit is valid. Certainly that lawsuits can get thrown out, and there are plenty of meritless lawsuits that are filed. But it's not a good situation.
Okay.
All right, so I actually went back because of the question from Trustee Yee. Let's see. We went through, I'm sorry, where were we? We were on experts. We had not gotten to delegation. Right? Yes, this is where we were, I believe. Okay, so you have a duty personally to perform responsibilities of the trusteeship except as a prudent person might delegate their responsibilities to others. And this is fundamental in trust law, recognizing that you cannot and should not do everything, certainly in a system such as CalPERS. But then the question is, did you delegate prudently? And we come back to this notion I mentioned earlier as to the Howard case and the independent appraisal. This was recited in the Tibble case as well. The fact that a fiduciary secured independent advice does not necessarily indicate that he or she acted prudently. The question is, who is giving that advice, and is it prudent to rely on that advice? How good is the advice? So prudent relates to, do you delegate? If you do, how are you delegating? To whom are you delegating? And then how are you supervising? So you can't simply, you should not delegate and walk away. You delegate and then you supervise. This notion of delegation is not only in the Restatement of Trusts, but also in the Prudent Investor Act. So you can delegate investment and management functions as a prudent trustee with comparable skills would properly delegate under the circumstances. All right, so that's delegation. Now, another topic that relates to prudence and your responsibilities as a trustee, you act as a board, and you are the highest authority, the governing body of the entire system. You will receive information that is proprietary and confidential to the organization, and it is your duty and responsibility as a trustee to maintain that confidentially. So you receive attorney-client privileges, privileged information. That privilege is with the board or the system if the staff is managing a particular topic. You receive confidential health information of your members. It's your duty also to retain that confidentially. You also receive confidential investment-related information that's proprietary to your partners, to those with whom you invest, and the value of your investments may be negatively impacted if you disclose material that you're not supposed to. So it's really important, and as a matter of law, it's a requirement that you not disclose confidential information of the retirement system to third parties.
Mr. Miller?
Oh, I had a
Yes.
question on that topic.
Sure.
Earlier, Ms. Taylor had mentioned that, we could conclude serving out our term in jail if we were, for some reason incarcerated, because we really have no mechanism for consequences for failures of good behavior, certainly as elected board members. And so I wonder if I, as a board member, would breach, have an ethical breach in which I provided confidential information that had a material negative impact on the fund or one of our investments or something. Would I be in jeopardy of, civil action against me by the board or other partners or stakeholders for that kind of thing? Would there be some potential consequence to me?
The answer to that question depends upon what type of information you're talking about and who is challenging you. The board has certain responsibilities to govern itself and its and ability to govern its members, but its authority only goes so far. If you are sharing confidential information of an investment manager who considers it to be a proprietary trade secret, that investment manager could come after you, certainly. If you were violating a statute, the California Government Code has a provision that says statutes that don't have a particular remedy, if you violate them, it's a misdemeanor. The local law enforcement authorities, if they decide to come after a particular trustee, it's usually for a variety of different things, but maybe not. That could be another venue. So it just depends on who's going to take issue with that violation and what authority they have in response. So I would not say that there's no consequence of your actions. I think there are very huge consequences of your actions, potentially, depending upon what the violation is.
Mr. Ruffin? Oh, okay. Okay, that's okay, go. Oh, wait, Mr. Slayton.
Well, David raises an interesting point, so I want to ask the question just a little differently, or another scenario. So let's say the aggrieved party, because you talked about essentially, part of it is based on who's the damaged party.
Right.
So obviously a developer who is damaged by the release of confidential information has some potential action.
Right.
Right? So let's suppose, just for sake of argument, that the damaged party is CalPERS.
Right.
And so an investment ends up not being able to be done or not being able to be done as well, and so the system is harmed.
Right.
Does the system have the ability to take action against someone who revealed information that then caused that reduction in value or that harm, if you will?
Typically, I would look at that question also in light of who is the one who's being alleged as having done the wrongdoing, and who's the potential one who's disciplining the person. So if it's a member of CalPERS investment staff, certainly you'd look up the chain, you'd look to your CIO presumably, maybe the CEO as well, I'm not sure, but that would be an employment matter that would be dealt with that way.
Right.
If you're looking at, say, a board member, the ultimate authority is the governing board, is the board. So I would think that that type of matter would be resolved by the board itself. And typically the point person is the president of the board. If the president is the one who's engaging in the wrongdoing, then it's the vice president. And that's how you set authority. And you determine how matters should be handled.
Can I add something to that?
Sure.
Sure.
I think if you're talking about a civil lawsuit,
That's what I'm referring
Right.
to.
Oh.
Yeah,
as opposed to discipline,
Oh,
correct. I'm
yeah.
talking about civil.
the entity, CalPERS, would be the plaintiff.
Okay.
And would have a cause of action. Alternatively, it could be the beneficiaries who
Correct.
might bring it
Correct.
as well on behalf of the agency.
Gotcha. Thank you.
I believe there's current law that says that that a trustee on its own board can't sue its own board while they're on the board. I'm not certain about that, but I don't want to speak too much off the cuff here in terms of how that plays out. Maybe that, but anyway, the point is I'm focusing more on discipline, which is how this typically plays out in terms of board issues rather than lawsuits. But there are lawsuits about all sorts of things.
Actually, we were sued once by a board member. I think it was a former controller, I think. not the current controller, but a former controller.
While on the
On-
board? While on the board?
While on the board, I think there was, am
Well,
I?
that's true, right, because you have ex officio
Kathleen.
members. Yeah.
Yes.
Well, then maybe that's
O'Connell.
different.
Yeah, Kathleen
Yes.
O'Connell. yeah.
Right, but with the hat of the controller.
Yeah, of
Or
course.
the hat of the state treasurer. So,
Right.
so they've taken off their fiduciary hat, and they're now wearing their
Okay.
other hat. Right, so that's a different scenario, I think.
That's why there's lots of lawyers.
Yeah.
Okay.
All right,
Okay.
let's move on, because we still need to get to duty of loyalty. So duty of prudence, though, this is a final summary. So what do you need to do to comply with your fiduciary duty of care? You do need to ask questions, and you need to understand the rationale of actions before taking them. You need to analyze the advice that you're getting and the recommendations you're receiving from experts, and not act as a rubber stamp. But also, if you're not adopting the experts' recommendations, you have to have a reasonable base for doing so that's informed by the applicable expertise. I've said this before, but I'm summarizing it now. And prudence also does require that you follow the law applicable to you. So you have the PEARL, you have PEPRA, you have a variety of other laws that apply to the plan. Those compose the PEARL, the plan document. You got to follow that law, as well as the board regulations and policies that you adopt yourself. You are a self-regulating agency to some degree. You've been given some authority to do that, and you need to follow those rules too. Fiduciary duty of loyalty. So now we're to the second prong of fiduciary duty, starting with the exclusive benefit rule, which states the fundamental premise that you are managing trust funds, and you are supposed to spend those trust funds for the exclusive benefit of members and beneficiaries and defraying reasonable expenses of administering the system. That's the exclusive benefit rule. The Constitution also articulates an aspect of the duty of loyalty that pertains to your job as fiduciaries of CalPERS, and that is to administer the system in a way that will assure the prompt payment of benefits to members and beneficiaries when they're due. You have a primary duty of loyalty to members and beneficiaries. Sometimes people talk about fiduciary duties you owe to others. You do not owe any fiduciary duties to anyone other than your members and beneficiaries. You do not owe fiduciary duties to your plan sponsors. You do not owe fiduciary duties to any other stakeholders within the system. You owe other duties to them. This constitutional statute that's on slide 42 states as a secondary duty the duty to minimize employer contributions. What does that mean? It means don't overcharge the employer. Don't set unreasonably short periods within which you are collecting your contributions. Diversify your assets. Try to maximize your return and minimize your losses so that you are actually making earnings on the contributions that come into the system so that you can use that value to pay for promised benefits. Those all, I think, are reasonable ways to minimize employer contributions. But ultimately, we come back to the primary duty, which is to the members and beneficiaries. The question of duty to employers or whether a board is putting the interest of the employers ahead of the membership is really the key that was addressed in the O'Neill case that was remanded and now recently just decided today tentatively in favor of the board. But this language is important to note nonetheless, and that is an abuse of discretion occurs when a trustee acts from an improper, although not dishonest motive, such as when an act is undertaken in good faith, but for a purpose other than to further the purpose of the trust, or more specifically, the one for which the power is granted. So if, in this case, the question was the retirement system in taking these actuarially recommended steps, or actuarially at least endorsed steps, to dampen the impact of the market crash, improperly favoring the interest of the employer, in that case the county of Stanislaus and other participating employers, over the interests of the members and beneficiaries. The trial court has now appeared to have found that they did not, that they were actually had the interests of the members and beneficiaries very much in mind. And this wasn't simply about keeping their job today. It was about preserving the actuarial soundness of the retirement system in the future, preserving the funding, using funding methodologies that would address this significant event. And there are a lot of analogies to, there's an analogy to the controlled burn that a firefighter will make in order to, they'll start a fire in order to avoid a bigger fire. And that's kind of an interesting analogy, I think, where you may do things that in the short term are beneficial to your very important participating employers, but you're doing that because it is ultimately in the overall best interest of your members and beneficiaries. And it's important to articulate that point. So one of the things that this court went through is they went through and said, well, what did this trustee say at a particular meeting? What did the minutes reflect? How did they vote? They came up. And some of the people who were challenging the action actually had voted for some of the now contested actions. So that, it does matter to some degree. Nobody was on the hook for personal liability there, but it was just, it matters how they expressed their opinions and whether it was fiduciarily sound or not, or could be fiduciarily supported. A question comes up from time to time in the context of the duty of loyalty question about collateral interests. Are trustees engaging in activities that are because they have another interest that they're trying to serve rather than the one that they're supposed to be serving on the retirement board? And sometimes this comes up, or at least the challenge is in the context of a social or political issue. I thought I had another slide on that. So the point is that it's not, you're not to be making decisions that are motivated by a social or a political issue. You're supposed to be making decisions that are in the best interest of your members and beneficiaries. The fact that something has a social benefit is not a bad thing. It's a very good thing. But it doesn't take precedence over the ultimate goal, which is, are you managing the trust in a prudent way for the benefit of your members and beneficiaries? Retirement security. There's a recognition within all trusts, and I think just in a more, even more extreme way in a trust such as a CalPERS, where you have the active member who joined yesterday who's 25, and you have the retired member who's drawing a benefit, not paying a contribution, and is living paycheck to paycheck, who's 80. Those beneficiaries are going to have some different interests. In terms of what their contribution rates are in the case of the active member, how much in a supplemental benefit might be paid in the case of the older retiree who's living paycheck to paycheck. And there's a recognition in trust law that this duty is complex and some interests can be cross-cutting. The interests of your safety members on something may be different from the interests of your miscellaneous or general members. And so that's why you do need to keep in mind what is the overall best interest of all of of everyone whom we serve as participants or beneficiaries. And the appropriate balance may not be obvious when the interests are not the same. Luckily, or fortunately, trust law has afforded you quite a bit of discretion when analyzing the merits or demerits of different courses of action as they apply to different groups of members and beneficiaries. You need to be fair. In this quote, it talks about income and remainder beneficiaries. So your income beneficiaries are people drawing a retirement check now. Your remainder beneficiaries are those who are not going to draw it until they retire. What do you do when you have this conflict? Well, first you look to your law. You look to the plan. What does the plan say about this particular topic, if it says anything at all? I think it's reasonable to consider the scope of the issue. How many people are involved? What is affected? The degree of hardship, potentially to some degree. You're not a court of equity, so you can't go too far in this. But you are fiduciaries, so you are to consider equitable matters. And then certainly you are to consider whether a particular proposal implicates vested rights and do what you can to preserve vested rights within the the limitations of the law that applies to you. On the duty of loyalty, you are not to administer the trust as an agent for another. So we all understand that for retirement boards in California, the statutes that apply to all of you say how you get on the board. You're either elected by the retirees or you're elected by the active members. You're appointed by the governor in the case of CalPERS, or you come in as an ex officio member from the controller's office. Once you get here, though, you are all fiduciaries with the same responsibilities. And this issue has actually been addressed by the U.S. Supreme Court in the context of an ERISA fund, because ERISA funds also often will have a union appointed and a management appointed member of the boards. But the traditional fiduciary duty laws apply equally to all of you. And I've included some of that key language on this slide. Yes. Or, sorry.
Hold on, Dave, Mr. Miller?
Yeah. In the context of this duty of loyalty or even prudence, how do you have any advice for us on things that may, the thing that presents itself is somewhat limited, but you're aware that it has kind of knock-on effects or implications for a lot of other people or other things that are beyond what's immediately before you, and if you make this decision, it could then change and have, you know, adverse effects beyond. How do you?
Are you talking about adverse effects on other portions of the membership, or something different?
Right, or you know, just the application of a particular principle that this would change how it's, and would then kind of, you know,
The ripple effect.
First domino in a number.
I think
of
that's very important. I don't think that you should be myopic in your thinking. I think that you should take the big picture in mind with respect to your entire scope of responsibilities.
Thank you.
It's a little bit like, I don't know if this is right, your chief actuary, he's sitting out there somewhere, I think, and I'm not sure but I think that, not sure he'll agree, but I think it's similar to the notion that when you're choosing actuarial methodologies or assumptions, they have to be reasonable independently and collectively. So I think it's the same thing when you're making other decisions. They have to be reasonable based on what's presented to you and also in the context of your whole plan. So ripple effect is important to think about.
Thank you.
Yes.
Mr. Slayton?
So could we go back to the conflicting interest among members and beneficiaries?
Sure.
So I'm going to raise an issue of conflicting interest between some beneficiaries and other beneficiaries, which I presume would be a similar
Yes.
situation. So we have a terminated agency pool, and this was an issue that for the new board members we faced some time ago, where we had 8 very tiny agencies that had to, for their own reasons, decided they couldn't pay. So they couldn't continue in the fund, and we have a procedure to put them into a terminated agency pool. The balance in the terminated agency pool is fairly significant. I don't remember what the number is, but it's millions of dollars that are in that terminated agency pool. Meanwhile, we face a situation with cutting potential 60% cut in beneficiary payments because of the rules of the terminated agency pool to a 60% cut or whatever the number was for a very small number of people. And yet they're in a pool that today doesn't mean it would happen in the future, because if you had a large agency go into that pool, the numbers could change radically fairly quickly. But we are where we are, and so that was an issue in my mind. How do we wrestle with that, where you're also having to deal with scale and trying to protect a fund against something that could happen in the future but may never happen in the future. Mm-hmm. And meanwhile, these people have their lives to go on. Do you have a thought about that at all?
I think your question and observation implicates perhaps the comment from Trustee Miller about ripple effect, and also relates to plan provisions and how you prudently administer a plan. You can't prudently administer a trust fund if your employers aren't paying contributions that they're required to pay. And you have to then look to what is your remedy if the employers aren't paying. And CalPERS has a few more specific remedies, particularly as to contracting agencies, than some other pension plans. So invoking a remedy that's available to you in that context reasonably so as to address something that is utterly unacceptable, which is the failure to pay employer contributions into the plan, may be the right choice, even though it impacts in a very unfortunate way a small group of people. The assets may be pooled for investment purposes, but they are not necessarily in that context, might not be allocated or supposed to be used for that particular group because they haven't paid in. So that's a great example of what I'm talking about. And I think reasonable minds can and will differ about how to balance those interests. But you do have to, in an organization as large as CalPERS, and I'd say even in a small organization, to retain integrity, you need to have rules that you follow. So when you set up rules that are fiduciarily appropriate, following them is probably the right plan, unless new information has come to you to say, well, maybe we need to modify this to some degree given these current circumstances. So I think that's my very general observation.
So just to follow on that a little bit. So we have the flexibility to create a set of rules for handling these types of situations, provided we feel it's prudent in terms of treating everyone as equally as we can.
Well, I'm
given
not giving you a legal opinion on this
No, I
specific
understand that.
circumstance.
I understand.
Because I would defer to your general
Right.
counsel on that.
Right.
And it depends how hard set the rule is. And it depends what sort of precedent you might be setting. It may be this one small employer, but you may be able to see that if you do this for this one, it's going to be have this negative consequence. So that I would defer to.
Okay.
To you in consultation with your general
Okay.
counsel or in a different context.
Yeah, it gets
to
pretty gnarly
discuss about
pretty quickly. Yeah. Okay.
that
Thank you.
topic. Yeah. Okay. But a great question. These are very very difficult. All right, so we've talked a little bit about employer contributions. Bant and Claypool were the cases before O'Neill that talked about this, and they said that you can take actions that result in reducing employer contributions so long as those actions don't compromise the competency of assets to pay the promised benefits. There's no conflict of interest in doing so. You're not doing this because it's going to give you something back personally. And the actions in the overall best interest of members and beneficiaries. This question of conflict of interest personally has come up in other litigation, Lexon being the primary one that comes to mind, the Supreme Court case, which recognizes that there are certain activities that you engage in and must engage in as a retirement board that will have an impact on the finances of your employed members to the extent that they impact, say, their contribution rate. That in and of itself is not enough to give rise to a conflict of interest because you are here only because of your employee the fact that you are an employee. But if it has a different financial interest that's more peculiar or particular to you, then you have to be concerned. And the O'Neill decision did endorse the concept that a board could potentially consider its active members' interest in retaining their jobs when making funding decisions, but it's caveated a little bit by whether or not a single-year employment warrants making a huge concession to an employer. What the trial court ultimately concluded is that this wasn't about just saving jobs at a particular moment in time. This was a much more fundamental fiduciary decision that the board was making about the actual funding of the system. All right, I think I've talked about this case enough. So what do you do to comply with these rules and to avoid an abuse of discretion, which is the standard that should apply to most of your decision making? It's a pretty high level of deference that's afforded to you. First of all, process is important. Make sure that the record reflects the process that you're engaging in, whether it's your board meeting minutes or it is the agenda material that's provided to you, the expert reports that are provided. Make sure that it shows that you are deliberating with your fiduciary duties in mind. Do they reflect that you're being prudent? Do they reflect that if you need expert advice that you are getting it and that you're reasonably relying on it, or it is reasonable to rely on it? And are you acting in the best interest of members and beneficiaries? Are you educating yourself? Do you have active independent oversight in the areas that matter for a particular decision? And then legal consultation and compliance with the law, of course, is a given. I've included here a final sort of summation of the fiduciary goal that I think you're all familiar with from our various trainings. But to reiterate, use your informed judgment, act in the overall best interest of members and beneficiaries, do so in a way that complies with the law that applies to you. You do have plenary authority over administration and investments, but don't do that, and you may not do that in a way that's arbitrary or capricious, and it must be rationally related to the information that's presented to you. More questions?
Can you give an example, or maybe what we do for active independent investment oversight? Is that from the boards? We're being overseen?
So the question was, how do you exercise your obligation of oversight over investments? Was that
referring to us or to the fund in general?
us? I didn't catch the last word. Us or?
Or the fund in general?
Fiduciary responsibilities apply to anyone who has decision-making authority or makes recommendations to those who have decision-making authority. So you all are fiduciaries, and this applies to all of you as trustees. Certainly your executive staff are fiduciaries to the organization as well. So you all have to exercise prudence. You all have to exercise your responsibilities, compliance with your duty of loyalty. Did I answer your question?
No, Margaret did.
It was for Margaret?
I answered it. I answered it.
Oh, you answered it. Okay.
Yeah.
Was it just yes?
No, he wasn't sure if we were being overseen.
What was
Oh,
the,
you were
well,
being overseen. Oh, well, that's a good question. Yes, you were being overseen. You are, because courts will always remind you you are being overseen. So you have plenary authority, except that you are subject to judicial review. And courts will always remind you of that when you're in court on this issue. If you try to assert too much plenary authority, they will say, well, no, we get the ultimate decision on this. And ultimately, it's the California Supreme Court, if it doesn't go to the federal courts. Yes.
Mr. Miller?
Oh, I'm sorry, President, yes.
Oh. In the context of my duty to participate and to how does kind of recusing or not participating in a decision play into that in terms of, I was elected to participate, but if there's a situation where for whatever reasons, personal, or whatever, I say, no, I'm not going to participate. Is there any case law where someone has been challenged for recusing themselves or not voting on something? And
That's a really interesting question.
Then, go.
Yeah, so you must recuse yourself when you have a personal
Right.
financial interest as defined by law. And you must recuse yourself if you are biased. So on a particular topic, you know the people involved, you know you can't be fair. But you have a fiduciary responsibility to engage in the activities of the organization. And if you abdicate those responsibilities by not appearing, by overly recusing, maybe somebody could make an issue out of it. It's certainly part of your fiduciary responsibility is attending meetings and being informed and voting. But you have a right and responsibility to recuse under the appropriate circumstance.
So it
So that's
sounds
where I'd
like-
say talk to the general counsel before the meeting. Make sure that you are considering properly all the different factors before overly, recusing too often.
Yeah, so I guess what it sounds like is that the decision to vote or recuse would properly be considered subject to those duties itself as a decision, and you'd be held to that
Exactly.
standard
You
when
would not be
deciding.
complying with your fiduciary duty of either prudence or loyalty if you were to vote on a matter where you were conflicted, where you
And-
should have been recusing.
And kind of related, but we don't do business, we don't do business on the basis of a consensus. We vote on things, and there's, I like to think that most of the time there's a pretty strong consensus, but occasionally there's a dissenting point of view, and being the crazy idea guy, I can see myself in that situation occasionally, where I would be dissenting from a decision. But once a decision or an action is taken by the board, how does my duty of loyalty and everything come into the execution of those decisions versus, something that could be viewed as, undermining those? Is there case law on that?
Case law doesn't come to mind immediately, but what I would say is it is healthy to debate. It is an example of good fiduciary decision-making to have people who express differences of opinion. There's nothing wrong with that at all. If you vote unanimously on the matter, there's nothing wrong with that either. But there should be circumstances where you disagree with one another and you have a healthy debate. Once the board has made a decision and the majority has decided to pursue a course of action, I think that the most responsible thing to do as a fiduciary is to follow that course of action unless there is new information, new set of circumstances that warrants revisiting it. It is not productive as a board of trustees to continue to revisit the same issue over and over without a change in circumstance. But you have this ongoing duty to monitor in all of the areas in which you work. So, I think that's my answer. I don't think that undermining your fellow board members on things that you have decided as a board to do is an appropriate course of action. On the other hand, to be the one who continues to remind people about certain principles, that's fine. That's what you should be doing.
Great, thank you.
Ms. Brown?
Thank you. Actually, we've been talking, I look at fiduciary duty, and I look at it in terms of investments and making sure there's, the money to pay the benefits. But, we also administer health benefits. And, there's always concern that we're going to maybe reduce benefits to keep the cost down, or I'm just wondering how our fiduciary duty makes us responsible for the health benefits that our members receive as well. Or does it?
You're administering a trust for health benefits, correct? No. Yes. So your fiduciary's in that role as well when you're managing a trust for health benefits. So the same principles would apply.
So that the promises made, so we look at the plan and the promises that were made to those beneficiaries of the health plan make us fiduciaries. Is that?
Well, that's right. There are different laws that apply to pensions versus health benefits in terms of, say, how enforceable a promise is, whether it's vested or not, for example. And that's been addressed by the California Supreme Court in the Riot case. So I don't want to opine on a particular, I don't think it's appropriate for me to opine right here on a particular health benefit, but the general principle of being prudent and acting in the best interest of your members and beneficiaries applies to any trust that you administer.
Yeah, and I'm just thinking for like state employees who have, maybe benefits up until they reach Medicare age, that we make sure that those keep going and that we don't end up somehow doing something to cut those benefits because it saves us money or because costs are rising so much, the state can't afford to pay for them or something. I don't exactly know how it would work, but I just want to make sure that everybody on the board knows that we also have a fiduciary benefit to benefit the pensioners for the people who get health care.
right, but
Because not
under-
everybody gets health care.
Now, I'm not a tax lawyer, but I certainly know that under federal tax law, you have to segregate the assets for health can't be used for pension. And many systems, retirement systems, are simply the administrator of health benefits. They're not actually, it's the employer who's promising the benefits. It's not statutory, it's contractual under agreements, under labor agreements. So different sets of rules may apply in that context. There also may be certain types of benefits. This is actually something that was discussed in a really interesting way in the recent Supreme Court oral argument in the CAL FIRE case about, the extent of vesting or not vesting to various types of benefits. Your fiduciary duties have to be informed by the law that's applicable to the particular benefit that you're administering. So that's also a caveat.
Yeah, I think that's right. I mean, to sum it up, the contractual duties and the contracts involved in establishing the trust are very different for health benefits as opposed to pension benefits. And so yes, it's a trust, but the question becomes a trust for whom and who put the money in, and so it's a different situation.
It might be helpful to have some education on what those rules and roles are for the board on that as well, since we have, almost 1.5 million total covered lives. So it'd be helpful probably to get some training on that as well.
Yes, I would support that. Okay.
So,
Mr. Slayton.
yeah, I want to build on the question from Ms. Brown. Maybe we can get some clarification right now on the issue of fiduciary duty. My understanding is the only trust we have is in the PPO side, where there's actually a trust fund where we're self-funding. So my question really is that the focus of where there's actually, there may be other duties, but where there's a fiduciary duty, does it solely apply to the trust on the PPO side?
I don't know.
Okay. Well, open question then.
Okay. Well, you can respond when we come back for that additional training with that also. Okay.
Good questions.
Okay.
Need my health lawyers there.
Okay. Okay. Any other questions from board members? Okay, well, seeing none, thank you, Matt and Ashley, for an informative session. That concludes all the public sessions of our off-site meeting. And the session over the last 3 days have been very informative and productive. And I want to thank everyone for their participation, for the excellent presentations from our CalPERS experts and guest speakers. And just to advise the board, you have a letter from the League of California Cities before you, and I'm going to have this put on the next board governance committee for discussion. So that's where that one would go. And so with that, we thank the members of the audience, and thank you for joining us. And Karen, a few housekeeping comments.
Thank you, Henry. Our next regular board and committee meetings are scheduled just a few weeks from now on February 19th through the 21st at our CalPERS headquarters in Sacramento. And remember, you can always view our meetings online as well on our website, so please feel free to do that. And board members, please complete all of your surveys, day 1 through 3. And if you need any assistance with that, please email me and I'm happy to help you. Thank you, everyone. Have a safe drive home. The board's going to take a quick break and come back in 15 minutes at 12:40 p.m. for closed session. Thank you all.
Okay.